now we shall head over to Macau, where we will hear from Ms. LIN Chi Nga. So over to you, Ms. Lin.
Thank you so much. Just let me share my screen first. Okay, everyone can see, right? Okay, let's start. First of all, I would like. Okay. Okay, Okay, first of all, I would like to thank Professor Wolf and Professor Gallagher for this opportunity to learn from all of you and share some of my research findings. The topic of my paper today is the supplementary role of the law of unjust enrichment in Macau. As one of the jurisdictions in Asia, Macau has been using the body of rules of unjust enrichment until today due to the historical influence of the Portuguese law. Condicio, the obligation of restitution can be generated under many different regimes besides the law of unjust enrichment. Therefore, the legislator chooses to set up an order of application of these regimes. Also, the supplementary nature of the unjust enrichment is a result of the application of commutative justice when facing other values such as the protection of bona fides, the legal certainty, and stability. The norm which provides this supplementary nature is Article 468 of the Macau Civil Code. According to this article, cases where the unjust enrichment cannot be applied due to its supplementary characteristic are divided into three categories. The first one is the aggrieved party is granted other remedies to obtain compensation for damages or restitution through other regimes. And the second one is the law denies the right to receive restitution. And the final one is the law decides to provide other effects for the situation of profiting unjustly. This classification is also adopted by most of the legal scholars. Among these three, the definition of the first category is particularly vague and inaccurate. First of all, the remedies that the law provides for the aggrieved party to receive restitution and remedies to obtain compensation should be separated and divided into two different categories. The reason is that the obligation of restitution based on the law of unjust enrichment should correspond to other types of obligations of restitution provided by the law instead of obligations of compensation for damages. Secondly, if the victim has the right to claim damages and at the same time the fact conforms to the application of the law of unjust enrichment, it will lead to the concurrence of petitions. Only in this situation, the obligation of restitution due to unjust enrichment is complementary per se, or in a narrow sense, and which means that two requests can be raised simultaneously, but the request of restitution based on the unjust enrichment must be an auxiliary one. Other situations mentioned above are merely complementary in a broad sense, or more accurately, they are only supplementary. Now I'm going to briefly introduce some of the most commonly discussed regimes that have priority over the law of unjust enrichment as for the better understanding of the upcoming part. Firstly, there are mainly two other types of obligations of restitution, the one of invalidity of legal transactions and the obligation due to the rescission of contracts. According to Article 282, Paragraph 1 of the Macau Civil Code, when a legal transaction is declared to be null or cancelled, the party who has received payment from the counterparty has to return everything they received because of the retrospective effect. This type of obligation of restitution is different from the legal effects that the obligation of restitution based on the unjust enrichment produces. The former means that everything needs to be restored to their original state as if the transaction has never been made, while the content of the latter only includes the amount obtained due to the loss of the aggrieved party. The rescission of a contract has the retrospective effect as well, which signifies that the content of restitution includes more than the one calculated by the rules of unjust enrichment. This is because in a commutative and onerous contract, when the performance becomes impossible and the debtor is imputable for this, the creditor can terminate the contract even if he or she is not entitled to any compensation for damages, and the creditor has the right to ask for the restitution of made payment. However, if the failure to perform is not imputable to the debtor, the creditor is only entitled to the restitution in accordance with the provisions of unjust enrichment. That is to say, the reason why the creditor in the former case can demand the return of all payments made is that the legislator literally wants to punish the debtor for his or her fault. And besides obligations of restitution, there are other types of methods which the legislator chooses to solve the problem in the case of unfair gains. I'm going to talk about two of them which have obtained most attention. The first one is the obligations of compensation for damages. The liability for damages in the Macau Civil Code can emerge from many situations, not only from civil liability, but also from the faults formed during the contract formation, non-performance or delay of performance of obligation, and liability for risk, etc. The reason why the obligation of compensation for damages arising from civil liability has become the focus of discussion is that it is more common in practice, and also because the application of this regime and its coordination with the obligation of restitution caused by unjust enrichment creates considerable difficulties, and the opinions of the scholars vary. When there is an infringement on other people's property or rights, the application of two regimes will compete when identifying the facts. In this type of circumstances, the victim is often aggrieved and the infringer gets the benefit. When there is a discrepancy between the amount of loss and the amount of compensation for damages, especially when the latter is higher than or at least equal to the former, how to apply these two regimes is of great significance to the victim, who is also the aggrieved party in such cases. This is because of one provision, the provision of Article 487 of the Macau Civil Code, in which it states that when the actor only had negligence in civil liability, the court can determine the amount of compensation for damages at a lower level according to the principle of equity. It means that the decision of the court can be made under considerations of the extent of the actor's negligence, the economic situations of the actor and the victim, and other circumstances related to the incidents, such as other common practices of similar judicial precedents, changes of the local currency value, and the inflation rate. To put it simply, the court may determine an amount of compensation which is less than the actual value of damages. Therefore, if the party is not allowed to claim for restitution based on the law of unjust enrichment as an auxiliary request, it might cause the victim unable to recover all of his or her losses. The second type of the most concerned and debated regimes are the rules of prescription, acquisitive prescription, and lapse. Such norms belong to the situation where the law denies the right for restitution and reflect the considerations of the legislator, which is abandoning the correction of the fact of unfair gains because of other values that are superior to transactional justice, despite that the restitution is feasible and desirable in such cases. In the case of these three regimes, the legislator chose to apply them in priority, not only because it is more important to protect the stability of the legal system, but also because of the purpose of punishing the lazy arbitrary, as well as public order and legal certainty. Besides these three regimes, another emblematic example in which the law denies the right to claim restitution is the protection of bona fides. For instance, a possessor in good faith does not need to restitute the civil and natural fruits, and the bona fide third party that has registered can effectively obtain the real estate when there is an unlawful situation of one house sold twice. And now we come to the second part of this article. Some disputable issues and difficulties will be discussed, and there are some questions to be raised here. The first one is the role of the Doctrine of Causa in the regime of unjust enrichment. In the legal system of Portugal and Macau, the concept causa in the second legal requirements, no reasonable causa, are divided into three categories: the reason of payment, the reason of obligation, which is legal transaction, and other reasons of property transfer. If we try to incorporate the various types of regime that are concurrent with the unjust enrichment into these three types of causas, we can see which regimes that share the same situation of no reasonable causa can have priority application. And among all these regimes, those in which the legislator chooses to deny the obligation of restitution seems to be different. Unlike other regimes, the application of prescription, acquisitive prescription, and lapse does not take precedent because of the unfair gains under these circumstances are also without any causa. But on the contrary, the application of these provisions is regarded as the exact causa granted by the law. Therefore, when the prescription of the right to claim for restitution in lacto sensu has completed or lapsed, or when the ownership is passed to the possessor due to the completion of acquisitive prescription, the payment made has turned the transaction from no causa to with causa. The concurrence between these regimes and unjust enrichment cannot be seen as existed, as the former does not overlap with the latter. If there is no concurrence between these regimes, this is illogical to include them into Article 468 of the Macau Civil Code, because if there are no overlaps, there should be no application sequence needed. Another regime that deserves attention is accession. Like other regimes, it is concurrent with the regime of unjust enrichment, but with a speciality. In general, if the regime of unjust enrichment is to be applied, one must prove that the gains of the beneficiary come from his or her loss, and there is not any reasonable cause as justification. However, as stated in the provisions of accession, the legislator does not give other effects or deny the application of restitution. Instead, the rules of unjust enrichment shall be directly applied. More importantly, the legislator also exempts the aggrieved party from meeting the three legal requirements and gives that whenever the situation of accession occurred, the calculation rules of unjust enrichment shall be used to calculate the value of objects for restitution. To sum up, the legislator decides that the provisions of accession are applied in preference to those of unjust enrichment, just that the effects produced are in fact completely consistent. The concurrence of actions is another hot topic discussed by scholars, if not the hottest one. The problem is that whether the plaintiff should be allowed to file a petition for restitution based on unjust enrichment and file another one at the same time. The question of how to correctly interpret Article 491, paragraph 4 of the Macau Civil Code, which is 498, paragraph 4 of the Portuguese Civil Code, has aroused academic discussions, especially the opposite fields of CUHK and Untitled Chapter, which are best known on this issue. The complete content of Article 491, paragraph 4 is that completion of the prescription of the right to claim for compensation for damages shall not result in the completion of the prescription of the right to claim for restitution of property and the right to claim for restitution of unjust enrichment. According to the opinion of Unjust Enrichment, the mechanism provided by this article in the Portuguese Civil Code is beneficial to the victim, because with regard to paragraph 1 of the same article, the prescription starts from the time when the victim is aware of his or her right, even if the person who should be held responsible remains unknown at that point. And however, the prescription of the right to claim for restitution will only begin when the aggrieved party knows about his or her right, and also the identity of the person who should be held responsible. In other words, the 3 years prescription starts when two conditions are met. Nonetheless, whether this benefit exists in Macau is questioned here by this article. If one compares carefully the two provisions, Article 491, paragraph 1 of the Macau Civil Code and Article 498, paragraph 1 of the Portuguese Civil Code, one will find that there is a slight difference between them. The prescription of the former starts only when the victim is aware of his or her right and also know the identity of the person who should be held responsible. If one takes a closer look at the norm of the prescription of the right to claim for restitution of unjust enrichment and does a comparison, one can confirm that the prescription of the two rights are very close, since Article 476 of the Macau Civil Code provides that the right to claim for restitution of unjust enrichment will complete within 3 years from the moment that the obligee is informed or should be informed of his or her right and who the debtor is. And the general prescription also applies to the right to sue, which means that 15 years after the date of the incident, the prescription will be completed. In this case, the prescription of the right to claim for restitution of unjust enrichment and the one of the right to claim for damages due to civil liability basically start at the same time. And therefore, this part in Article 491, paragraph 4 does not make sense in the Macau legal system. When Unjust Enrichment believes that the existence of Article 498, paragraph 4 of the Portuguese Civil Code guarantees the chance of the victim who is the aggrieved party simultaneously, to claim for restitution when the action of compensation of damages due to civil liability is unsuccessful. CUHK thinks that what this article points out is that the action of the former will not impact the victim to sue for the latter, so there is no reason to force the victim to file a lawsuit for damages in the first place. The approach of Unjust Enrichment seems to be more comprehensive to protect the interests of the aggrieved party. Although the party has to file a lawsuit for damages arisen from civil liability, it is possible to subsidiarily claim for restitution to prevent the court from applying Article 487 of the Macau Civil Code and allowing the actor to compensate less than the victim's actual loss. There was a case in Macau in which the opinion of the judges was congruent to the approach proposed by Unjust Enrichment. However, although this method appears to be the greatest protection provided to the plaintiff, it is undeniable that the freedom of choice is missing. In addition to the philosophical significance of this freedom, that is the question of political value put forward, unless the reason of doing so is to impair the plaintiff to use a less favorable method. This freedom of choice has practical significance to the sensible parties. The civil liability regime has more legal requirements, and the final amount of compensation is not necessarily higher than the amount of restitution of unjust enrichment of the defendant. Moreover, granting the choice to the victim will not prevent him or her to use the model of main and subsidiary petitions. In this way, the setting of the supplementary characteristic of the obligation of unjust enrichment would be seen as outsmarting itself and gilding the lily. Besides the above-mentioned concurrence, the action of unjust enrichment may also compete with actions of other regimes, such as the restitution of property, the declaration of nullity, the contractual performance, and the termination of contracts, etc. One of the most worthy of scrutiny is the situation when the action of cancellation lapses. In this case, the reason of ruling out the option of suing for restitution of unjust enrichment in the first place is because of the possibility of claiming for a cancellation of a transaction. According to the logical reasoning, since the right to sue for declaration of cancellation has lapsed, it means that the only way left for the aggrieved party to claim the losses back is the actions of unjust enrichment, and it therefore should be allowed. But scholars such as Menendez Leitão and CUHK and others have other opinions. They believe that the invalidation of rights should prevent the parties from filing a lawsuit based on unjust enrichment, and the ground they give is very, very simple. If this was not the case, the original intent of the legislator would be completely disregarded. The debates on the concurrence of actions in fact raise two other sub-questions. The first one is that can the supplementary nature of the obligation of unjust enrichment really avoid conflicts of legislative purposes? If the original intent behind the norm set by the legislator should not be ignored, it would directly affect the way people interpret such provisions, and this kind of influence usually appears in the form of restricting the angle of understanding. Therefore, in the above inference, some scholars believe that since the legislator has already set a time limitation for the exercise of rights, the parties should no longer be allowed to use other legal remedies to achieve their goals, because it is largely ignoring the intent of the legislator. However, this point of view is questioned by this article. If priority should always be given to the legislative intent when trying to understand a provision, then other problems would arise in the regime of unjust enrichment. Besides the situation of allowing the aggrieved party to claim for restitution when the right to seek cancellation is expired, using the supplementary nature of unjust enrichment to circumvent the possible utilization of Article 487, which we just mentioned, may also constitute a violation of the original intent of the legislator. Since the court may reduce the amount of compensation according to the principle of equity, to put it more straightforward, the victim may be asked to bear part of damages due to his or her sound financial condition and the actor's poor financial condition, even if the victim does not have any fault in influencing or guiding the ultimate conduct of the actor. So I see that my time has come to an end, so I just briefly included. there is a second sub-question, and I would like to explain it further if I have the opportunity. So to conclude, under the haunting uncertainty created by the choice of the legislator, the unsolved problem of the content of causa, the conflict of values protected by the law, and the lack of options, which is not necessarily beneficial to the victim, and the narrow scope of application in practice, the possible violation of the principle of private autonomy, etc., which I might explain later if I have the chance. More in-depth study of the regime for the sake of improvement of the Macau civil law system in the academic field, in my opinion, is strongly suggested. And thank you so much for your attention.
Okay, thank you, Ms. Lim, for your presentation.